What is a prosecutor? A prosecutor is a district attorney and an elected official in our county responsible for making the decision of whether or not to charge a crime. A crime may be charged if it is found that there is probable cause. This means that there is a reasonable likelihood that this crime occurred. But the district attorney may decide not to charge this crime unless they find the evidence suggests that the person is guilty beyond a reasonable doubt. Under our system of laws, the choice of whether or not to charge lies solely with the district attorney. Homicide is a crime where the harm caused is the death of another person. The Wisconsin legislature defines this in 3 different categories: intentional homicide, reckless homicide, and negligent homicide. Intentional homicide occurs when there is intent to kill another person. Reckless homicide occurs when the person engages in behavior that creates a substantial and unreasonable risk of great bodily harm or death. Negligent homicide occurs when the person uses a dangerous instrument such as a gun, a bomb, a car, or even a vicious animal. And although this person doesn't intend to cause harm to the other person, they should have known that the behavior they were engaging in created a risk of death or great bodily harm. When deciding whether or not to charge a crime, the prosecutor must decide what particular charge they will bring that best fits the facts of the case. Next, the prosecutor must decide whether the evidence shows and meets the legal elements of the crime charged. If the prosecutor does not believe that he can prove these elements at trial beyond a reasonable doubt, he or she will usually decide not to charge. Next, we will be discussing defenses. Just as the Wisconsin legislature decides what constitutes a crime, they also define when a person is exempted from prosecution for behavior that would be otherwise deemed criminal.